class. Just a word of warning. There's some very bad weather happening in the area of town that I live. Thunder and lightning and everything. I love the rain. I'm not complaining about the rain. But my connectivity is very fragile. My Wi-Fi doesn't like bad weather. If I lose connectivity, then we'll just have to stop and we'll make another plan. But for the time being, let's not waste any time. Let's carry on. We are still busy finishing off Unit 4. Unit 4, the other further requirements for a valid contract. We need to finish 5, 6, and 7 this week. So that's quite, although it's not actually that much. It sounds worse than it is. I'm going to share my page. Okay, just confirm to me if you can see my shared screen. Just give me a thumbs up. Daniel can see it. Benjamin can see it. Okay, it's the same document that I've been using for previous classes that I'm saving and continuing to use. In due course, I will neaten it up and also share that with you. Word of warning, however, my class notes, my lecture notes that I make while I'm teaching do not replace the actual notes on e-learning. The notes that you need to study are on e-learning. Okay, so we're looking at, we spent time looking at consensus. Now we're looking at the other requirements that are necessary for a contract to be valid. Although we spent more time on consensus than on the other requirements, you cannot say that consensus is the most important requirement. Without consensus, there is no contract. However, even if there is consensus, if the other requirements are not present, then the contract will not be valid. On that note, where am I now? Possible test or exam question. This is what I would refer to as a distinction question. In all my assessments, I like to bring in 1 or 2 questions that are slightly higher, of a slightly higher level than the rest of the questions. To really separate my top of the class question students from the rest. That's why I call them distinction questions. There will always be enough other questions that anybody. Please keep your mics off. There will be enough other questions that anybody that has been attending classes, listening to the recordings, and has studied will pass. But I like to throw in one or two that are at a slightly different level. This is one of them, but I've literally just given you the answer. So who's going to try to answer that quickly? Question there. Consensus is the most important requirement for a valid contract. True or false? Who's going to try? Quick, quick, quick. Don't want to waste time. Okay, I've literally just given you the answer. Don't think about that. I'm not going to waste time. I'm going to carry on. We've looked at possibility of performance. Performance must be determinable. It must be physically possible. If it is objectively impossible, nobody can do this, the contract will be void. If it is subjectively impossible, then the contract is still valid. So moving on then. Performance must be legal. Sorry, didn't want to put that there. That's where I want that. Performance must be legal. If performance of the contract is against the law, the contract will be invalid. So, for example, dealing in drugs, dealing in unlicensed diamonds, unlicensed firearms, those are fairly obvious, self-explanatory examples of contracts that are against the law. But this is not the only category of contracts that are against the law and accordingly void. Sometimes contracts will also be void because they are against the good morals, against our good morals. So an example of that would be if a father promises to give a young man $500,000 if he doesn't marry his daughter. Now, there's no actual law against paying somebody not to marry your daughter. So you won't go to this father will not go to jail. He's not breaking the law. But you will all agree that paying somebody not to marry your daughter because you don't like that man is not the type of thing that we agree to. It's not something that we think is a very morally correct thing to do. And that contract will accordingly also be invalid. One aspect that you need to know, I just quickly, give me a second, I want to get my notes because I want to give you the page reference. There's one particular aspect regarding the fact that contracts must be legal, that if performance is not legal, will be aware of. That page 25 of the notes. Page 25, the so-called contract in restraint of trade. This was in last year's exam, so it is something I'm not promising you I'm going to ask it again, but I might well ask this question again. So firstly, what is a contract in restraint of trade? Contract of restraint of trade is an agreement that limits a contractual party to do a specific job for a agreed period of time. Geographical area. These restraints of trade are quite common. Many employment contracts or deeds of sale just going to get the precise wording here from the notes. Oh, that didn't copy, never mind. Let's try that again. Okay, that does want to copy, never mind, doesn't matter. So very often, if you accept a job, your contract of employment will contain a restraint of trade, which will specify something in the line of, because you are being trained, etc., etc., should you resign from your employer, you may not work as whatever you've been trained for within the district of Windhoek for 2 years or something like that. It's also very common when people sell a business. If Johnny sells his restaurant to Susie, then Susie doesn't want Johnny to go and open another restaurant across the street, because then all her customers are going to go to Johnny's restaurant. So the contract of sale will contain a restraint of trade. Purpose of a restraint of trade is the protection of goodwill. Goodwill, the ability to draw customers, protection of goodwill and trade secrets. Now, why are we talking about a restraint of trade in the context of discussing that the performance of a contract must be legal? Because a restraint of trade brings two constitutional principles in conflict. And remember, our Namibian constitution is a law. So a contract which is against the provision, which is contrary to the provisions of the Namibian constitution, will be illegal, and accordingly it will be void. Now, what are these two constitutional principles? The first one is that everybody has the right to work to follow the trade or do the work that they wish to do. Article 21, you don't need to remember the number of the article in the Namibian Constitution, but it is in the notes. Article 21 of the Namibian Constitution says, all persons shall have the right to practice any profession or carry on any occupation, trade, or business. So a contractual clause, a contractual provision, which says you may not work as a chef in a restaurant for 2 years, is contrary to that provision which says all persons have the right to practice any provision or profession or carry on any occupation. So from that point of view, it seems it might be, administrative trade might be void and unenforceable. On the other hand, it is also a principle of our law that contracts that have been entered into freely must be upheld. So if you entered into a contract with this provision, then this contract must be upheld, and you must abide by this contract that you entered into. So you will see there is this conflict between these two provisions, which raises the question, is the restraint of trade valid and enforceable? How do we answer this question? How do our courts address in previous court cases? How have our courts addressed this conflict between these two principles? Terms of court judgments in our Namibian courts, they are restraints of trades are generally as valid. So they put more weight to the second more emphasis on the principle that contracts must be upheld. That doesn't say however, that a restraint of trade will always be enforced. The party that wants to escape the restraint must provide evidence that it is unfair or unreasonable. So just to give illustrate by way of an example. If Johnny sells his restaurant and there's a restraint of trade saying he may not work as a chef for a period of 2 years within the district of Windhoek, that would probably be regarded as reasonable and serving a purpose. If, however, the restraint of trade is that he may not work as a chef for a period of 10 years within the whole of Southern Africa, that would be seen as unreasonable and the court will set it aside. The section is discussed in quite some detail in the notes. Make a note to go through the notes in that regard. And then the last of our 5 requirements are formalities. We started off with contracts. We learned that contracts can be informal. Getting a taxi, buying airtime, buying a shirt. You didn't sign a 5-page document, but it's still a binding contract. So the general principle in general, formalities are not required unless required by law. There are some laws that require some certain contracts to be in writing. An example, for example, if you're buying land, it has to be in writing and signed. So a contract for the purchase of property, immovable property, land, if it's not in writing and signed, it will not be valid. Buying a car, buying a shirt, buying airtime does not have to be in writing. So generally not required unless required by law or the parties agree between them. So if you are negotiating a contract, you can agree between the two of you that the contract will not be binding until such a time as it has been reduced to writing and signed. Okay, that's then the end of Unit 4. Any questions about Unit 4? Any questions? Okay, let's move on then. Unit 5. Unit 5 deals with terms of a contract. So going forward, and please understand this very well, going forward, we have now done the requirements for a valid contract. So our contract that we're learning about now is valid. Terms of a contract, the content of a contract. Some commonly used things that people put in written contracts or oral contracts, but these are mostly, we'll find them in written contracts. So terms of a contract, contractual provisions, the content of a contract. There are different categories of terms of a contract. You get express terms. Express terms are literally what it says. This is what the contractual parties have agreed upon expressly. If I agree with Rushay that she will buy my cell phone for $500 and pay me at the end of the month, express terms are buying and selling the cell phone, $500 payment at the end of the month. Those are our express terms. In addition to express terms, you will also sometimes in a contract find tacit terms. A tacit term is not express, but is required to for the contract to give effect to the true intention of the parties. So this is a term, these are the tacit terms, are terms that are read into a contract to make sure that the contract can be executed. The example that I have in the study guide, for example, which I think makes it quite clear, is, let's say, who can I use this time? Let's say George. Let's say George is a top football player. Are you a top football player, George?
Yes, I am.
Great, great. So George is a top football player, and he signs an agreement with Ramblers, whatever club, that he will play for them. And they will pay him a monthly amount. He's turning professional. The club is going to pay him to play for them. So the contract is that he agrees to play for Wanderers, Ramblers, whatever that I had, for $5,000 a month. A tacit term of this contract would be that he will attend the practices. So he cannot just pitch up on match day and say, I want to play, but he hasn't come to a single practice. And if they say, no, but we haven't put you in the team because you didn't come to practices, he tries to argue, but my contract doesn't say anything about attending practices. For the proper execution of this professional sports contract, it is a tacit term that he will attend the practices, even if it's not actually written in the contract. So does that illustrate the concept of a tacit term? Something which is read, something additional, which is read into a contract to give effect to the true intention between the parties. Similar to tacit terms, but not exactly the same, so don't confuse them, are implied terms. Implied terms are natural legal consequences. When we get to purchase and sale, we're going to be looking, for example, at all the implied terms that follow simply because your contract is a contract of purchase and sale. Just an example, an implied term of a contract of purchase and sale is that the thing that is sold must not be defective. So those are consequences that the law reads into. They don't have to be expressly discussed. They don't have to be put down, stated in the contract, but they will apply in all circumstances when you are dealing with a specific type of contract. So those are the three categories of terms. And there, oh, and then also, sorry, there's another one. And my bullet points aren't working here. Not going to struggle. Incidental terms. Those are your extras. So they are not implied, they don't follow by law, they are not essential for the proper execution of the contract, but the parties can agree upon them if they should so want to. Now, for the rest of the unit, we will be looking very, very briefly at some examples of typical incidental terms. Question that you can be expecting. Identify the following terms of a contract. So I give you the example and you have to indicate to me what type of contractual term this is. The first one that we look at are conditions. Something that I absolutely hate. Makes my hair stand on end every time I see this. Sure, you've seen this before. T's and C's apply. Have you seen that or heard that? People advertising something and they say T's and C's apply. Have you come across that? George has come across that. George, please, the next time you come across the statement T's and C's apply, please think of me and how much I hate this. And Severinus, you will as well, and Daniel. T's and C's, now let me tell you why this is utter nonsense. T's and C's is an abbreviation for terms and conditions. Apply. But a condition is a term of a contract. So to say terms and conditions apply is stupid, because then you're literally saying terms and terms apply, because a condition isn't something different. It is merely a type of term. That's my rant. What is a condition? A condition is a contractual term that makes the operation dependent on the happening or not happening of an uncertain future event. Let's give an example. I agree with Evelina that she can rent a room in my house if she passes introduction to law for Okay, but that's a bad example because I was going to say if she passes introduction to law for accountants, but that's not an uncertain future event because we're pretty sure she is going to pass introduction to law for accountants. So that's a bad example. Evelina, you can borrow my umbrella if it rains tomorrow. So our agreement is that Evelina can borrow my umbrella. Whether there is going to be performance, whether I'm going to deliver the umbrella to her so that she can use it, will depend on the uncertain future event. If it rains tomorrow, we are not certain that it is going to rain tomorrow. So whether this contract is going to, whether there's going to be performance in terms of the contract, whether the operation of the contract is going to proceed or not, depends on whether or not an uncertain future event happens. Now we get two types of conditions, namely a resolutive condition and a suspensive condition. You need to know the difference between these two. If the condition is resolutive, performance has started. But will come to an end if the uncertain future event takes place. So a resolutive condition, let's give you an example of that. Okay, my examples that I have here are all taken from the world of sport. Cricketer A agrees with cricketer B that B may use her equipment until she needs it herself. Please keep your mics muted. Let's stick to the, let's stick to Evelina and the umbrella. Evelina can use my umbrella until I need it myself. So she starts using it. The agreement is Evelina can use my umbrella. She starts using it. Performance has started. But there's an uncertain future event until I need it myself. We don't know when or if ever I'm going to need it myself. But if that takes place, I need it myself, the contract will come to an end. She has to return the umbrella. A suspensive condition. Performance is suspended. If the until, so there is an agreement, but no performance has started. It will only start if and when this uncertain future event happens. Evelina can borrow my umbrella when it rains. So she's not borrowing it yet. We have an agreement that she can borrow it, but there's been no performance. I haven't handed it over. She's not borrowing it yet. An uncertain future event when it rains. We don't know when this is going to be, if it's going to be. So performance will only start when it starts raining, when the uncertain future event happens. Is everybody with me here? You need to be able to recognize a condition and tell me whether this is suspensive or resolutive. Then we get a time clause. A time clause is similar to a condition. I'm actually going to copy and paste here so that you can see how similar it is. Contractual term, except with a condition, we are referring to something that we don't know whether it is going to happen or not. Time clause, something that is definitely going to happen. In fact, this example is not a condition. Why am I saying that's not a condition? Talk to me quickly. That one there that I had here, Evelina can borrow my umbrella when it rains. Why is that a time clause and not a condition? Yes, George. George, you've got your hand up.
Yes, there is no condition in that statement. A condition only happens if there is the word if, so they are not sure. That's a condition. But in this case, Evelina can borrow my umbrella when it rains. It's a statement without a condition in it. So if the rain starts falling, Evelina can use the umbrella.
George, George, you are on the right track. It is about the statement when it rains or if it rains. Whether is it going to rain again? Is there going to be rain in Namibia again? Yes or no?
Yes.
Yes. We don't know when. So it might not be certain in the sense that we don't know when it's going to rain, but it's something that will definitely happen in the future. So at some stage, it will rain again. So that's not an uncertain future event. However, if we say, if it rains tomorrow, sorry, my note taking is confusing here. Should have said that then. Evelina can borrow my umbrella if it rains tomorrow. Do we know that it's definitely for sure 100% certain going to rain tomorrow? No, we don't. It might rain, it might not rain. So that is an uncertain future event. But saying when it rains, it will definitely at some stage rain, so that's not uncertain. So sorry if my examples confused you there a little bit. A condition relates to an uncertain future event. A time clause relates to something that is going to happen. Time clauses can also be suspensive, or resolutive. As is the case with conditions, you get resolutive conditions and suspensive conditions. Similarly, you get suspensive time clauses and resolutive time clauses. The meaning of suspensive and resolutive is the same. Suspensive, no performance. Performance only starts when the certain future event takes place. Resolutive, performance has started. Will come to an end when the future event takes place. Is everybody with me? Is everybody comfortable with this? Benjamin is comfortable. Great.
Yes, ma'am.
Wonderful. Nigel is also comfortable. Okay, this is important, people. Another potential test question. Each of the following instances indicate is subject to a condition or a time clause and whether it is suspensive or resolutive. Easy to do. How do you do this? What is the methodology behind this? Read the term that I've given you, the extract from the contract, and identify the future event. So you read it and you decide what am I referring to? What future event am I referring to? Then decide, is the uncertain or certain? Is this definitely going to happen, or are you not sure that it's going to happen? If it's definitely going to happen, it's a time clause. If you're not sure whether it will happen, then it's a condition. Then you decide, is it suspensive or resolutive? Has performance started? Or will performance in the future, which will give you then, is it, if performance has already started but will come to an end, it's resolutive. Easy to remember. Resolutive almost sounds like dissolve, resolve. You resolve a problem, which means the problem goes away. Suspensive, it's hanging, it's suspended. Okay, everybody with me? The rest of the contractual terms in this unit are fairly straightforward. I will not ask you to give me an example. I will give you the example and ask you to identify the particular contractual term. This question that I had over here, identify the following terms of a contract. So the first one is a modus. What is a modus? A modus is a contractual term which burdens the contractual party's rights in terms of the contract. So, in fact, the implication of a modus is you will get rights, but you will only get these rights if you have render some performance, you have to do something in the future, etc., etc. The example that I have in the study guide, page 27, City of Windhoek sells a property to a wealthy businessman, subject thereto that he must use it to erect low-cost housing. So he can buy the property, but obtaining ownership of the property is burdened by his duty to erect low-cost housing. So it also relates to something that must happen in the future, but don't confuse it with a condition. Because if he doesn't do what he is supposed to do in terms of the modus, the contract will not come to an end. Contract, like the case of a condition, contract will continue to exist and he will in fact be in breach of contract. The next unit we look at, Unit 6, deals with breach of contract. A warranty, I'm literally not even going to type out what a warranty is. A warranty is exactly what it means in the English language. So you buy a new cell phone and it comes with a warranty. Another word for warranty is a guarantee. In fact, I will not penalize you if you use the word guarantee rather than warranty. They mean exactly the same. A cancellation clause, once again, is exactly what it says. It gives, in the event of something going wrong in the contract, it gives the innocent party the right to cancel the contract. Penalty clause, also exactly what it says. If one of the parties does not perform properly or performed on time, the other party has the right to claim penalties, a fixed pre-agreed sum of money. penalty clauses, very common in building contracts. You agree that somebody will build a wall for you and they must be finished by the end of the month. If they're not finished in time, the penalty clause activates and they have to pay you $100 a day. An entrenchment clause, easy to understand, although this is perhaps not a language that you're familiar with. An entrenchment clause you will only find in a written contract. It is an agreement that if you want to make any changes to the contract, must be made in writing. So if I have agreed with Severinus that he can rent a room in my house and he must pay me $500 a month, and our contract contains, and it's a written agreement, and our contract contains an entrenchment clause. If he comes to me a month later and says, well, he's a bit broke, and I say, okay, you only need to pay $300. And I accept the $300, and then the next month he only pays $300. And I say, no, where's the $500? And he says, no, but you agreed that I only have to pay $300. That oral agreement that he only has to pay $300 will not be valid and enforceable, because there was an entrenchment clause which says changes have to be made in writing. Okay, that was Unit 5. Quick. Any questions about Unit 5? Okay, that's actually all I set out to do for tonight. We still need to do Unit 6 and 7, but they are actually very brief. So I'm going to stop here for now. I've done what I planned to do for tonight. Seems to be finishing a little bit earlier, which is great. It's only 9 o'clock, but then you can all get back to your families and your lives a little bit earlier. Any final questions? Okay. If there are no questions, thank you very, very much for joining. I'm enjoying teaching you. I will download the recording and share on WhatsApp, like I've been doing in the past, if you want to re-listen or make sure that you've got everything. Have a wonderful evening.